thank you for your unparalleled partnership. Today's announcement addresses corruption at the highest levels of city government. The indictment unsealed today can be summarized in 3 words: quid pro quo. We allege that Ingrid Lewis Martin engaged in a long-running bribery, money laundering, and conspiracy scheme by using her position and authority as the chief advisor to the New York City mayor, the second highest position in city government, to illegally influence city decisions in exchange for in excess of $100,000 in cash and other benefits for herself and her son, Glenn Martin II. Accordingly, both Lewis Martin and Glenn Martin II are charged in the New York State Supreme Court indictment with bribe receiving in the 1st degree, a Class B felony, money laundering in the 3rd degree, a Class D felony, and conspiracy in the 4th degree. The charges encompass the vast majority of defendant Lewis Martin's time as chief advisor. Their conduct is one half of the quid pro quo equation. The other charges pertain to the other half, those who sought access by paying bribes. We allege that real estate developers and business owners Rosada Pinky Vaid and Mayank Dovidi paid for access and influence to the tune of more than $100,000. They each are charged with bribery in the 1st degree and conspiracy in the 4th degree. Vaid and Dovidi own private Manhattan businesses and properties, including the Glass Ceiling, a rooftop bar near Herald Square, and the hotel on Rivington on the Lower East Side. Both these properties had construction permits pending with the Department of Buildings during various times of this investigation. We allege that Lewis Martin acted as an on-call consultant for Vaid and Dovidi, serving at their pleasure to resolve whatever issues they had with DOB on their construction projects. And she did so without regard for security considerations and with utter and complete disregard for DOB's expertise and the public servants who work there. On multiple occasions, Vaid and Dovidi asked Lewis Martin to use her official role to help them evade DOB's roles surrounding these 2 construction projects. And again, she delivered for them. Each time she received an ask, she complied. She would immediately flip their ask to DOB, sometimes without any moment's notice, reflexively, and on at least one occasion, flipping the exact language provided to her. And DOB complied, expediting a project or helping overturn the decision to reject a permit. Today's indictment alleges and portrays a clear picture. You do this for me, and I will do that for you. It was not what is in the best interest of the city of New York and those who live here, those who commute here, those who visit here. Plain and simple, it was for the best interest of the defendants. That is a disservice to New Yorkers. I'm going to talk in a moment about the exchange of money, but I want to note that even without the bribe payments here, the jumping to the front of the line, is naked cronyism that in and of itself is anathema to public service. But here money was exchanged. You'll see the flow of money right here. There are 2 $50,000 payments for a total of $100,000 received by Glenn Martin into a joint bank account that he and his mother had together. And these payments were made in the midst of asks by their co-conspirators pertaining to construction plans and DOB licensing. The first is a $50,000 cashier's check, and then the very next day, Vaid sent Martin a $50,000 personal check. He deposited both checks to joint accounts controlled by himself and Lewis Martin. He then transferred $50,000 from the joint account to an account for his DJ business. And he then used that money to purchase what you see here, a $113,000 2023 Porsche. It wasn't just cash and a car. It was also securing business opportunities for her son. Part of the bribery scheme was support for Glenn Martin's fashion line, where Vaid said that he had the son completely covered, according to Ingrid Lewis Martin. And in addition to the cash, the car, and the fashion line, was backing for a Chick-fil-A franchise, which we allege he had no experience to run. Lewis Martin herself knew that this was wrong, we allege. Accordingly, our allegations discuss her attempts to cover her tracks. First, Lewis Martin invited her co-conspirators to join Signal, the encrypted end-to-end communication acts. And she gave explicit instructions that the bribery scheme was to be perpetuated by Signal, we allege, saying, and this is furthest to my right, quote, "Please only use Signal for asks." And the indictment and the statement of facts spells out what those asks are in detail. She also instructed her co-defendant, Vaid, to use coded language if he were to use a text message. Text her to alert her there was a Signal message coming. Quote, "Next time, just text me," quote, "trying to reach you, and I will look for it." In addition to emphasizing coded communications, Lewis Martin also used her son as an intermediary to arrange meetings, relay messages, and receive money and other benefits. Before I close, I want to say a few things that I want to be very clear about them. Three things. The first, these charges do not allege any criminal conduct by Mayor Eric Adams. The mayor is not a target of our investigation, and we do not have evidence of criminal conduct by the mayor. Second, these charges should not cause us to lose sight of the great work done day in and day out by the countless public servants who make New York City run. I'm privileged on public safety matters in particular to work alongside a great team of deputy mayors and other leaders in this city, and I want to underscore our joint work together advancing public safety in this city. I'm fortunate to serve alongside these talented public servants. Third, we recently have had, both locally and beyond, a series of verbal attacks on law enforcement and prosecutors. In particular, prosecutors engaged in public corruption enforcement. I want to salute all those who do this important work, who follow the facts without fear or favor, and increasingly so in the face of these verbal attacks. Here at the Manhattan District Attorney's Office, we have a long history of doing this, dating back to when District Attorney Dewey had the seat I'm now privileged to hold. I am committed, as I have throughout my career as a state and federal prosecutor, to continue this fine tradition, and alongside our public safety work on guns and hate crimes and sex crimes, continue to prioritize this important public corruption work. Along with our partners at DOI, we will continue to root out corruption. We will continue to follow the facts wherever they go, and we will do so because New Yorkers deserve no less. Now on logistics, as some of you probably already know, the four defendants have surrendered. They're scheduled to be arraigned at 2:30 this afternoon in Part 95, 15th floor of 100 Center. Our investigation is ongoing. Let me now turn to our great partner, Commissioner Strauber.
Thank you, DA Bragg. City officials have an obligation to faithfully discharge the duties of their office and to uphold the law. Their hard work and sacrifice enables city government to act as it should, that is, in the public interest. And the overwhelming majority of New York City employees uphold these obligations, serving the public with integrity day in and day out. But today, we announce an indictment against Ingrid Lewis-Martin, the mayor's former chief advisor, for using her official position and the authority and influence associated with that position to enrich herself and her son. As charged, she used her senior role in city government to benefit two co-conspirators in exchange for cash in excess of $100,000 and support for her son's business ventures. The benefits Lewis-Martin allegedly provided to her co-conspirators include her personal assistance and intervention with the Department of Buildings in service of their construction projects. And, as is also alleged, she and her son engaged in financial transactions intended to conceal the source of the cash payments received. The conduct described in today's indictment, the monetizing of a senior government position for personal benefit, undermines fundamental principles of integrity in government. Those who pay to play get better, faster service, and those officials who sell their authority and influence to grease the wheels get paid handsomely. The conduct alleged thus diminishes trust in government officials, and unfairly tarnishes the reputations of the many public servants who use their office solely for public good. As I have said before in this context, New Yorkers deserve better. As I have also said, it is the New York City Department of Investigation's mission to find the facts and hold accountable those who engage in wrongdoing, whatever their position. As a city agency, DOI conducts its investigations confidentially and wholly independently of City Hall, working in collaboration with our federal and state law enforcement partners to protect the interests of all New Yorkers in effective city government that acts with integrity and transparency. Our investigation here is continuing, and I encourage anyone with information concerning bribery, fraud, or other illegal conduct relating to this investigation to contact DOI by email at tipline@doi.nyc.gov or by phone at 212-825-2828. Thank you again, DA Bragg, and your team of dedicated prosecutors who work closely with DOI on this investigation, as we have in so many others. And thank you to the DOI team, drawn from several of our investigative squads, for your tireless work on this case.
Sure. So we will get to your questions on this important matter, which is obviously why we're here. Some of us were here earlier this week for People versus Luigi Mangione, and wanted to give a brief update on that, as I know we've gotten some questions from some of you. Just for context, as we allege, the defendant in that case brazenly shot Mr. Thompson twice in Midtown Manhattan. It was targeted, premeditated, and meant to sow terror. Accordingly, we charged him here in Manhattan earlier this week with murder in the first degree, among additional charges, which carry the maximum sentence of life without parole. This morning, the defendant waived extradition in Pennsylvania and was picked up and is in the process of being transported by the NYPD here to New York. I'll let the Southern District for New York speak for itself about their plans, but I do want to note that speaking generally, we've had state prosecutions and federal prosecutions proceed as parallel matters, and we're in conversations with our law enforcement counterparts.
We're going to take on-topic questions about the Ingrid Lewis-Martin matter. Jimmy?
The investigation is ongoing, and I'm not going to talk about the contours of what we may or may not be looking at.
Thank you. I'm seeing in the statement that there's no record on this $100,000 loan letter from the UK. Was this never meant to be a loan? Is that what you're alleging, that this was just masked as a loan to be a bribe and all that?
That is correct. That's our allegation. Let me say a couple of things about that. First, and there's a footnote in the statement of facts on, I believe, footnote 1, which talks about the definition of a benefit. So even if it were a bona fide loan, that would still be captured by our bribery statute. You cannot monetize your office for a gift or a loan or any other kind of benefit. So that's one. Two, as you know, that is our allegation, and as that footnote says, based on our review of bank records, for instance, we talk about the flow of money here. There's no flow of money of $100,000 back in repaying that loan from these bank records. And so, yes, that is our allegation.
Can I also just ask, did Luigi Mangione herself ever share in this $100,000 or any of the other materials of value, or was it all just routed to us?
This is a joint bank account, right? So the $100,000 goes into a joint bank account over which they had joint committing and control. I can't speak, it's beyond, I don't know who's driving the Porsche, but I can tell you where the money went in, and many of you probably have joint bank accounts, so the money was within her control and authority. The money, in addition to this, we didn't spell this out, but the money also is for various personal items and things of that nature.
Mr. Bragg, 2 questions. Can you articulate what proof you have that there was a quid pro quo? And then secondly, how did this matter come on your radar?
I'm not going to talk about the genesis of the investigation. The statement of facts spells out, but I'll kind of just hit some highlights of sort of the quid pro quo. First of all, $100,000 payment to a public servant is extraordinary in and of itself. The timing of those payments, in and around the time of explicit asks for government service, flipping in one instance the exact message given by a co-conspirator, asking DOB to overrule the career of public servants with expertise and invalidate and go back on their decision-making. And then you get this. That's in part the answer to your question. If you read the statement of facts in total, you'll see it all. But without regard to safety considerations, with utter disregard to DOB's expertise, and the receipt of more than $100,000, including this Porsche, I think that's partially the answer to your question.
What was wrong with the building, if I can ask? Or what were the safety issues?
I'm not going to go beyond the 4 corners, but if you read the statement of facts, it spells out the answer to your question, the temporal considerations, showing the quid pro quo, and we'll prove the rest of it up at trial.
Laura?
Two questions. In the indictment, it says that the bride and the baby were invited to Gracie Mansion for a meeting with foreign dignitaries. Did they in fact go? Can you tell us which foreign dignitaries were there? And separately, that Ingrid Lewis Martin communicated with Senator Gillibrand about a visa issue. Is there any evidence that Senator Gillibrand helped out with the visa or was able to get it expedited?
So let me just take a step back first and talk about those allegations are included to show the context of the relationship, the access, and are not intended in any way to suggest complicity by others you just mentioned who are not defendants. They show the access, so being in City Hall sort of at that point in the administration, and it shows that the nature of the asks were not just limited to DOB. This was an unfettered, on-call, quid pro quo arrangement, and I'm not going to go beyond that.
Greg?
I'm staying within the statement of facts. There's a section in here on, not, and it appears to say that these architects submitted plans in August of 2013, which appeared to be rejected by the Department of Physics in their expertise. But then it appears to say that they just resubmitted the same plan in March of 2024, and that it was, after a little back and forth, it was approved. Is that, am I reading that correct?
Our allegations are that the $100,000 plus in bribery payments got that access and got the efforts of the second highest person in city government to move those decisions without regard to expertise and substance.
But use the same plan. That's what
Oh.
the phrasing within the statement of facts implies.
Yeah. I don't have it in front of me. We can talk afterwards. I believe it is, but I don't have the, well, yeah.
Did you say anything at all about the glass ceiling? What were any concerns, like within the universe? Well, by the way, this kind of stuff is public record anyway, because DOB is going to be putting stuff in, which goes along with what that is. But can you address it now? Like, what's the safety concerns with glass ceiling?
Well, what I will address now, because it's the sort of core of our allegation, is that the defendant, Ingrid Lewis Martin, that defendant, went ahead without asking any questions about safety considerations and set aside the judgment of the career public service. That's to the heart of the quid pro quo.
We're going to do two more. Courtney?
Here, probably involves the Department of Buildings, and case against the former commissioner of the Department of Buildings, or any connection between those two cases, and were there wiretaps on Ingrid Martin's phone?
So the charges are distinct. The case against former Commissioner Ulrich is proceeding, and I'm going to hold off on answering your second question, but invite you to go to court, at which point when you may hear or may not hear more.
Okay.
So a big part of this conspiracy is that Ingrid had asked these two businessmen and her son to use signal to communicate. Now, we see some texts here that are going back and forth. Who forgot to delete the texts on their signal account? And can you go into some of the other little small purchases here, like the luxury items you're saying aside from
So on the first, I'll answer that as sort of a general technological matter. You know, things are stored in different ways, and legal process such as search warrants and seizures of phones, you can sometimes get things that you may not be able to get through other process.
the other luxury items besides
I mean, this was the you know, obviously the big one. The other ones are sort of are as you just described. It's a variety of things. I don't right. I can't unpack it, but we can get you that information.
All right. Thank you all.